Be ready. 5 seconds.
A first information report was registered against the appellant for the offence punishable under Section 153A of the Indian Penal Code. Stop. The appellant filed a writ petition before the High Court of Judicature at Bombay for quashing the FIR. Stop. By the impugned judgment, the High Court has dismissed the writ petition. Stop. The appellant was a professor at Kolhapur, Maharashtra. Stop. He came to Kolhapur for employment. Stop. The appellant was a member of a WhatsApp group. Stop. The allegation of commission of offence is based on what was seen on his WhatsApp status. Stop. The state government has set out the precise text appearing on the WhatsApp status of the appellant in its counter affidavit. Stop para. The learned counsel appearing for the appellant submitted that by no stretch of the imagination, the words written on WhatsApp status by the appellant will promote disharmony or feelings of enmity, hatred or ill will between different religious, racial, language or regional groups or castes or communities. Stop. He submitted that the prosecution of the appellant was a complete abuse of the process of law. Stop. The learned counsel representing the respondent state of Maharashtra submitted that whether the words or signs of the appellant on his WhatsApp status promoted disharmony or feelings of enmity, hatred or ill will between different religious, racial, language or regional groups or castes or communities or not, is a matter of evidence. Stop. He submitted that it is only after examining the witnesses that the prosecution can establish the effect of these writings or signs on the minds of people. Stop. He submitted that at this stage, no conclusion regarding the impact of what is written by the appellant on the minds of the members of the public can be drawn. Stop. He would, therefore, submit that no interference is called for with the impugned judgment, and the trial may be allowed to proceed. Stop para. This court has read double quote intention quote close as an essential ingredient of the said offence. Stop. The alleged objectionable words or expressions used by the appellant, on its plain reading, cannot promote disharmony or feelings of enmity, hatred or ill will between different religious, racial, language or regional groups or castes or communities. Stop. The WhatsApp status of the appellant is an expression of his individual view to the abrogation of Article 370 of the Constitution of India. Stop. At its best, it is a protest, which is a part of his freedom of speech and expression guaranteed by Article 19(1)(a). Stop para. Now, the time has come to enlighten and educate our police machinery on the concept of freedom of speech and expression guaranteed by Article 19(1)(a) of the Constitution and the extent of reasonable restraint on their free speech and expression. Stop. They must be sensitized about the democratic values enshrined in our Constitution. Stop. For the same reasons, clause B of subsection 1 of section 153A of the IPC will not be attracted as what is depicted on the WhatsApp status of the appellant cannot be said to be prejudicial to the maintenance of harmony among various groups as stated therein. Stop. Thus, continuation of the prosecution of the appellant for the offence will be a gross abuse of the process of law. Stop. Accordingly, we set aside the impugned judgment of the High Court of Judicature at Bombay and quash the impugned FIR and the proceedings based on the impugned FIR. Stop.